Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast, and a warm welcome and a happy Remembrance Day to everybody in between. My name is Dan Balkaran, as you can see on the screen, and I'll be your employment lawyer for the next 30 minutes, answering all your questions about everything employment law. As always, and I'm an associate at Samfiru Tumarkin, Canada's leading employee side employment law firm. And as always, you can reach us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. So I think we've got a couple questions coming in. I'll deal with those first, and then hopefully the rest of you send your questions in. Otherwise, we can talk about some of the interesting employment law stuff that's happening in the news, like the tech sector layoffs, the Twitter layoffs, and then rehiring and all that stuff. Okay, so question from Maria. Can my employer put me back on a probation period a year into working my position? No. No. The short answer is no, right? So what is a probation period? Now, in a probation period generally is a period of time at the beginning of employment under which the employer arrogates to itself the right to terminate you and provide you with no severance, right? So the core basic principle and your only protection in employment law is, generally speaking, although not true for everybody, your only legal right in the event of your termination is severance, okay? And the amount of termination or the amount of severance you get gives you more leverage and perhaps more stickiness in your position. It's harder to fire you if you've got $150,000 coming to you versus if you have $3 coming to you. But probation periods are generally 3 months at the beginning of employment, and contractually, the employer says, well, we can fire you without paying you anything during that period. And you can't contract out of if you're provincially regulated, you can't contract out of the minimum protections of the Employment Standards Act, and each province has got an Employment Standards Act, and so generally speaking, although I'm only called in BC, I'm not called in Ontario or any other provinces, but generally speaking, and particularly in BC, there's no severance even at a minimum amount provided to you under the ESA for the first 3 months of your employment, and so for that reason, probation periods are generally confined to 3 months. But after, like, if they go longer than 3 months, a core principle of employment law in Canada is that you cannot, not only can you not contract out of the ESA if of the Employment Standards Act, if any termination clause could potentially violate the Employment Standards Act, that clause is void, and you get what's called the common law, which is bigger severance. We'll say it's much greater. It's closer to a month per year of service. And so, when your employer is saying, well, you've been here for a year, we're putting you on a probation period, what they're really saying is I think anyway, depends on what the terms of the probation period are, but they're saying, well, we arrogate to ourselves the right to terminate you without paying you severance. That squarely violates the ESA and voids whatever termination clause. It depends. Are they putting that in a contract, or are they just saying we're doing this to you? If they're just saying we're doing this to you and they purport to terminate you without providing you any severance, they'd be in violation of the ESA. But what is your contractual entitlement, or what is your entitlement under the Employment Standards Act, which would depend on your specific particulars. But short answer is no. However, if there's been some disciplinary thing, or where they're trying to say we're going to try you out, and then we reserve the right to terminate you, that's more of they're ceding the ground to terminate you for just cause, and just cause. You're, as I said earlier, your only legal right in the event of your termination is severance. Well, and the amount of your severance is sort of. It depends on what your employment contract says in terms of your entitlement to what size of severance. And then if you get the bigger severance, it also depends on your age, your length of service, and your position. But what just cause does is it allows the employer to terminate you without providing you anything, right? So if that's what they're talking about, because I don't have enough information from what you've posted there, but if that's what they're talking about, where they're ceding the ground for that, that would just depend on the nature of your infraction. So just cause is a legally justifiable way in which your employer can terminate you without paying you any money. However, because it's a bad outcome for society, if you're thrown out in the street with no money and no job, the law wants you to get severance. And so the bar for just cause is very high, and there's generally three ways to get there. One, a single act so egregious that the employer is justified no longer continuing the employment relationship. So that would be like, you punch your boss in the face, you come to work high on drugs or intoxicated, theft, fraud, committing an indictable offense, that kind of stuff. Or the more common one, an ongoing series of performance or conduct failures and an opportunity of which you're provided clear warning and an opportunity to correct same. So that would be your classic 3 written warnings and you're out. And the third one is a sort of cumulative cause. Just generally, you're not a good employee, and you're late all the time, and you're getting in conflicts with your coworkers, and your performance, the actual substance of your job isn't good, and there's a basket of things, so we can just get rid of you for all of them. But the longer you've been there, the harder it is to get to cumulative cause. And so if they're ceding the ground for that, it's more of analysis of that than whatever their probation period says. So, I mean, the short answer is, generally speaking, no. If they've promoted you, then, maybe they're putting you on a probation period to see whether or not they're going to undo the promotion. But even then, that's probably a constructive dismissal. So, I would probably, if they've done that, it probably doesn't matter because nothing's going to happen anyway. But if it does, I would contact an employment lawyer right away. And certainly you can reach us at helpemploymentlawyer.ca. And 1-855-821-5900. Okay, thanks, Maria. Jared, if an employer moves our location 20 kilometers away, should they have to provide me with additional compensation for the increased commute time? I mean, yeah, you could negotiate that, but that's not really an employment law question. So the question for you is, can they move you 20 kilometers away such that, and can you claim constructive dismissal for it, right? Like, so if somebody asks you to move, somebody moves, like if you're working, in a given location and it takes you 20 minutes to get to work, and then they say, well, now we want you to drive 2.5 hours to get to work. That wasn't the contract that you labored under before. And if they just impose that change upon you, has your employer constructively terminated your employment? Because remember what I said at the beginning of this session, your only legal right in the event of your termination is severance. You have to get to termination to get money, right? And if your employer hasn't explicitly terminated you, but has changed the fundamental conditions of your employment such that their actions are the same as a termination, then you could say, you know what, I consider your actions a termination of my employment, give me severance, right? Now, the problem with, well, not the problem, but the challenge with that argument is you have to be right. Okay, and if you're wrong, you effectively just quit. Okay, but that is potentially an option that's open to people where there's been a relocation. Now, the relocation has to be something that is reasonably significant. Like if your commute was half an hour and now it's 40 minutes, that's not going to get there, right? But if your commute was 5 minutes and now it's an hour and a half, that could certainly get there. So it depends on, how much the additional 20 kilometers takes you, and if you have a car and all that stuff, and if it's reasonable to impose upon you to get a car if you've never had a car. 20 kilometers, if you're driving from, I don't know actually where you are. So if you're driving from one suburb to another on the highway, I mean, that's nothing. That's 10 minutes. But if it's, you don't have a car, you live downtown, and it's, across the city, it's probably still nothing, but it's something to kick the tires on. But the question about should they have to provide me with additional compensation, I mean, it's open to you to negotiate that, but I'm not familiar with any mechanism that requires them to do that. There might be something under the Employment Standards Act or the Employment Standards regulations in your province, but I'm not familiar with it. And then it just sort of becomes a question of leverage, right? Like, do you have a lot of it? Or are you a 10-year employee who they can't live without? Or are you a 1-year employee who has no leverage, or are there a lot of jobs available in the job market and they can't afford to lose you, and what are you asking for, and is it worth it poking the bear, like it depends, and what your employer's like, and should you say, well, listen, I've got to take on an extra $100 a month in transportation costs. I want I want the company to pay for that. That just depends on your unique situation with the business, how they are, what your relationship with them and your leverage is. So, feel that one out. Some employers will get really upset about that. Others probably won't bat an eye. Generally speaking, employees have not had during my lifetime as much leverage as they have right now. So because of the historically tight labor market. So, take that all into consideration, and then you can decide if you want to bring that up in negotiation with your employer. But I don't have a magical way to force them to do that. But you may have a constructive dismissal claim. Probably not, but you may. And if you're interested in kicking the tires on that, again, constructive dismissal equals termination gets you to severance, which, if you're a 24-year employee with 24 months coming to you, you might want to look into that. So again, you can reach us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900 if you want to investigate in that. And you may, depending on how long you've been there for. I'll just say Rose. Rose asks, was just let go from my position after 20 years. I have an offer, but my employer gave me to sign, but how do I know it's fair? Well, right. You need to talk to an employment lawyer. Generally speaking, and I don't know if this is the case here, so I don't want to lead you astray here, Rose, because I don't know the facts of your specific situation other than you were there for 20 years. Employers are in the business of paying you as little as possible when you're let go, because you're just a dead liability on the books to them, right? Why would they want to pay you something fair? Now, employees are in the business of getting paid as much as possible, right? But that employers tend to play the percentages, okay? So, and what I mean by that is the vast majority of employees have no idea terminated employees have no idea what the law is, and just see, well, here's a little bit of money pursuant to the Employment Standards Act. Okay, that sounds right. I'll take it, okay? Or here's a little bit of money pursuant to the Employment Standards Act, plus a couple weeks extra. That sounds fair. It says quotes the statute, so I'll take it. But what you didn't know is your employer is paying you 20 cents on the dollar, right? And so when with an employment lawyer you can get 80 cents on the dollar, let's say, or 90 or whatever. So plus you're going to have tax considerations and how much you're going to lose out of that amount of taxes. So, Rose, you should not sign 100%. You should not sign that offer until you talk to an employment lawyer. More than anybody else I'm going to talk to you today, you need to talk to an employment lawyer immediately. If you want to talk to us, we're in Ontario, Alberta, and British Columbia. If you want to talk to us, employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. But Rose, right after this, go pick up the phone, talk to an employment lawyer, and just it's worth. You don't know what your entitlement is yet, but it's worth checking it out, because you don't want to be in a situation where they've offered you 15 cents in the dollar and you should be getting 90. So, okay. I don't know how to say this person's name, and it's unique enough that I'm not going to say it. So just use his or her first initial. V says, should my employer pay for my work done during the holiday time, pay for vacation pay on every paycheck? If it says salaried on the pay stub, I was paid hourly, not salary. Okay. So your rights in terms of your holiday pay and vacation pay are going to be, if you're a provincially regulated employer, are going to be in the Employment Standards Act or their attendant regulations. Generally speaking, you need to be paid for holidays that you work. Stat holidays, anyway, you need to get paid for. Vacation pay is generally speaking going to be, in BC anyways, it's 4% up until you're there for 5 years, and it becomes 6%. And does it have to say it on your paycheck? As long as you're getting that amount, probably not, but I don't see why it wouldn't. So, and if you're working during a stat holiday, it's going to be time and a half, I believe. But check out the Employment Standards Act in your area. It should contain a list of all of that information. So just Google whatever province you're in, Employment Standards Act. Now, what a lot of the provinces do is they will have their own website that answers your questions in a layperson friendly way, as opposed to showing you the statute. You can look up either one. It's the statute that gives you the proper information, but lawyers read statutes for a living, whereas average people don't. So or non-lawyers will say don't. So but you might want to look at both. So in BC, if you want to look up what the statute says, you can just go employment standard. You can Google, just go employment standards, BC Employment Standards Act, and then space BC space laws, and that'll get you to the statute directly. But yeah, I mean, it's your rights in terms of what you're supposed to be paid or will be enshrined there. And if you're provincially regulated, it'll be under the Canada Labour Code. But unfortunately, I don't have off the top of my head the exact specifics under there. I never had any holiday pay on worked holidays. It's the same person. B. Worked holidays for 2 years, only hourly. I don't know what you mean by the only hourly. Like you're getting paid hourly, but if you were working on a holiday, you have to get paid time and a half for the hours that you worked. Can't remember if you have to get paid the stat as well. But it sounds like you didn't get paid enough, so you're going to want to look at that, look at your legislation, and then talk to your employer about it if they're not paying you the correct amount of money. I don't know what this person is saying. Someone said they lost their appeal today. Beam me up. You're going to have to elaborate. I don't know what you're saying. Rhonda asks, can an employer cancel your shift an hour before you're scheduled to start and not provide you with any pay consideration for the missed hours? I actually don't know the answer to that question, Rhonda. I want to say that there has to be, I thought I recalled that there has to be some degree of notice that is provided to you, but I can't recall for certain. Oh, we have a visitor into the. Hold on a second. There you go. There you go, buddy. I don't know the answer to that question, Rhonda. I think you'll have to look up look up. It'll be in the Employment Standards Act in your area. I don't know if they can cancel your shift a minute before you start. I've never encountered that question before, but it should be provided for in the Employment Standards Act in your area or the attendant regulations. Sorry, I didn't have more information for you. Yeah, beam me up. I mean, that's gross misconduct. I don't know what you're referring to. You're going to have to give me more information. I don't know what appeal it was that you lost. I don't know what the allegation was against you. I don't know if this was a human rights matter. I don't know anything. So if you can give me some more information, I'll endeavor to answer your questions a little more. Anthony says, my employer wants me to move to a new position, but it's for less pay and work that I have no experience with. I'm worried that if I don't take the position, I'll be let go and out of work. What are my rights in this situation? Yeah, so again, 100% Anthony, you're going to want to talk to an employment lawyer for the reasons I'm going to set out. So you're only, again, the rights and protections to employees in Canada tend to be the most robust in the world, or fairly close to the most robust in the world, but they're still not that robust, right? Like your employer, your only legal right, like really your rights flow from termination, and that's what your leverage is, right? It's if you've been terminated, or what happens in the event that you're terminated, right? And so if your employer imposes this change upon you, like here's a new position and it's a reduction in pay, it could be that they've constructively terminated your employment. Now, constructive dismissal, you've all heard of constructive dismissal. As I said earlier, it's where the employer unilaterally imposes a fundamental change in the terms of your employment upon you, which you reject. Okay? That's what a constructive dismissal is. And the effect of it is that the employer's actions have de facto terminated your employment. Okay? So the moment you object, your employment's over, depending on how you object, right? But your employment is over at that point. You never work there again. And then it's an analysis of whether or not the employer's actions did amount to a constructive dismissal. And if so, then it's an evaluation of your severance. But you got to pass that, your severance amount. But you got to pass that first gateway of whether or not their actions were, the employer's actions were a constructive termination of your employment at law. So generally speaking, constructive termination comes up in two situations. When you're talking about a unilateral change, it's a reduction of your salary and or hours, reduction of your pay by above 10%, safer if it's 20, and or hours by the same amount, which results in the same amount of pay reduction to you. Okay, or a demotion, right? Now, a demotion can take on, a full-on demotion, like you were the VP of finance, now you're the janitor, or it could be you're still the VP of finance, but all your VP duties were taken away from you, and now you're effectively supervising tier 1 staff, right? That's called a hollowing out of your position, and because prestige and emotional satisfaction attached to your employment, hollowing out can also get you to constructive termination. And so, if your employer imposes this change upon you, right? So first of all, I'd say you can either try to negotiate with them not to do that, but it doesn't sound like you want to do that, or that's a good idea, or you can let them impose the change on you. You can don't agree to it, but you can, and don't sign anything saying that you agree to it. But you can work in it for a few days, and then you can say, then you can reject it and claim you've been constructively dismissed. But you don't want to do that without the benefit of tailored legal advice. There's so much that can go wrong there. You need to talk to an employment lawyer right away. But the only reason why you would reject it is if you want to get to termination because you have a decent amount of severance coming to you, right? So again, you can reach us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. You're going to want to find out exactly what your potential severance options are before you do anything, and you also need to, so that's one. Two, you need to kick the tires on how large a change is this. If it's a question of small degree, it's not going to be a constructive dismissal, right? And all of this might be moot because you'd rather stay at your employer even in the new position than move on, right? Depends on your age, how easy it's going to be for you to find a new job, all that stuff, right? So you want to get a good employment lawyer and talk your way through that with them, and go through the legal possibilities, severance possibilities, and practical effects and risks. And then you got to make your call. But here's the thing: if they impose this change on you, you got to maximum 2 months before you got to pull the trigger on claiming you've been constructively terminated. Otherwise, after that point in time, you're effectively have been deemed to accept the change. So you can't go back 6 months from now and say, "Oh, I was constructively dismissed when they put me in a new position," because now you worked in that role for enough time that's now your role. Okay. Carrie asks, my niece worked for a local manufacturer. She started in a student position and became full-time recently. She was never given a contract when moving to full-time. Should she request one? Absolutely not. Absolutely not. I get this question all the time. People are always very concerned about not having contracts. Generally speaking, you should not be, because I'm sorry, guys. I'm having a lot of technical difficulties with this guy over here. Generally speaking, you should not be. So if you go to work every day, so the core of your employment relationship is you go to work for a certain amount of hours in exchange for a certain amount of pay to do a certain amount of duties. That's it. Okay. And then there are a bunch of ancillary terms sort of sprinkled around that. And just because of that your rights aren't written down on a piece of paper doesn't mean that your rights and obligations aren't written down on a piece of paper, doesn't mean that they don't exist. It's just that there's a lack of precise certainty as to what they are. Things we can be certain about is we know that you go to work for a certain amount of hours, do a certain amount of duties for a certain amount of pay. All the rest of the stuff is, and you get benefits and whatever, but all the rest of the stuff is arguable. And so what an written employment contract does is it takes, this broad contract of employment that exists in the air between you and takes out some of the terms and writes them down so we have certainty on those terms so you can't get out of that. Okay. And so that an employer does that to protect its own financial position. So what an employment contract really is, from 99% of you, is that it's the employer exploits its superior bargaining power over you, the employee, at the time of contract formation to force you to agree to terms that are contrary to your best interest. That's what an employment contract is. It's not for you. Now, there are situations where it can be for you, but that's going to be somebody who's either a high net worth individual, someone who's very in demand, usually a C-suite employee who wants to dictate some of his or her terms and put them into the contract. If there's something specific you want in a contract, then maybe. But generally speaking, you don't want it in a contract because inevitably that's going to invite your employer to put a proper termination clause in your contract, limiting your severance. Remember, the vast majority of your rights really are encompassed in, when you get fired, you get severance. And employers can limit in a contract your severance from the common law, which is large, generally 1 month per year of service, to the Employment Standards Act minimums, which is small, generally 1 week per year of service to a maximum of 8 weeks. Okay, so no, you shouldn't have. If you have any doubt about this, Carrie, you need to talk to an employment lawyer.ca. Thank you, Carrie. Carrie likes my special guest. The special guest was Gandalf, my very, very old man cat who turned 14. Sorry about that, everybody, for him joining in. I'll see if I can get one more done before we wrap up. This is from Beam Me Up. I appealed my dismissal. I called my boss incompetent, and they're bypassed all warnings and straight terminated my contract. I think I've been discriminated against by my female bosses, and I also believe, and that's where it sort of ends, my dismissal is unlawful, unfair. Okay, so this is something that happens to me a lot when I talk to clients, which is they're more focused on what they believe because of their emotional experience with what happened, and they think that their value in their claim flows from that as opposed to the law. It doesn't. It flows from the law. Okay, and so how you feel emotionally, while important, is must be kept distinct from what your realistic legal position is. Okay. Now, in terms of the two substantive parts you talked about, I can't talk about your discrimination, although I will say, if you're trying to make an argument about female discrimination of a male employee, I think that's a tough road to go down. I have not seen that be successful in any human rights context in Canada. So that's a real tough one. The first thing you said, you called your boss incompetent. I don't know about bypassing all warning. They didn't warn you; they just fired you. Well, you got, so it sounds like you brought a human rights complaint and you lost based on your sort of the things that you said and for the reasons I outlined about the discrimination. But if they fired you because you called your boss incompetent and didn't pay you anything, they probably fired you for what's called just cause. As I talked about earlier, that's where they can fire you if they're right and pay you nothing. Because of your conduct effectively allowed them to bypass the severance regime. Okay, so just cause is very hard to predict with any accuracy how it's going to turn out, but the core of it is that the court does a contextual analysis, and that means your overall I don't want to use the word performance, but I'll just use that for now. But your overall history at the employer, such as your years of service, your lack of disciplinary history, all that stuff, good relationships, it changes how the seriousness potentially of your conduct. So there's a famous case in Ontario where a 20-year employee, I think he was a 19-year employee, punched his coworker in the face and broke his nose, and that was not just cause because he had 19 years of unblemished service. And so, whereas if he had been a 1-year employee and done that, it would have been just cause 100% of the time. And so, what you're talking about here is called insolence. Can you call your boss incompetent and continue to work there? Well, the question then becomes, was that said once in the heat of the moment? Did you apologize? Were you given an opportunity to apologize? And, was this a single incident, single infraction? And the underlying core test is it impossible for your employer? Is it impossible for you to continue to work there given what has happened in the relationship between you and your boss caused by you calling him incompetent? And I guess, what did he do, right? Is this just a standard boss, tried to discipline you a little bit or something and you overreacted? Or is this a situation where you've got some bosses are, they're abusive, it happens, where they're just yelling and swearing and throwing expletives at their employees all the time. So it depends on all of that. But, if you lost at the Human Rights Tribunal, that doesn't mean if you're within 2 years of your termination, you don't have an action for wrongful dismissal if they fired you for just cause, right? So beam me up. You might want to talk to an employment lawyer because you might have something. It just depends on your facts. You can reach us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, well, listen, that's all we have time for today. Thank you, everyone, for joining. Great questions, everybody. You can reach us our next session here is on Monday, November 14th, with Chris Justice. He will be laying down the law with all things employment law and all your questions employment law. I will be here in 2 weeks at my regular time slot, which is 10:30 a.m. Pacific time on Fridays. I will take steps to ensure that I no longer have the special guest that I have today. So thank you all for bearing with me while that occurred, but thank you for joining us. Great questions. Have a wonderful and safe weekend. And again, happy Remembrance Day. Maybe that's not the right word because of what the nature of Remembrance Day was, but I wish everyone a safe and wonderful Remembrance Day. Thank you.